Hello and welcome to our bite-sized collection of videos of employment law issues arising from the pandemic. My name is Sara Ibrahim and I'm joined by my colleague Emily Moore.
Hi Sara.
Hi Emily. So today we're going to be talking about the issue of fire and rehire. So in our series of COVID-related employment issues, we've already talked about redundancy, and what we're talking about today is fire and rehire. So this has been more commonly used in the pandemic as a result of employers claiming they cannot afford to retain the same number of workers and employees on the existing levels of pay and benefits. Emily, I think you had some TUC research that you wanted to talk us through.
Yes, Sara. So there was some research published at the end of January this year that found that nearly 1 in 10 workers had been told to reapply for their jobs on worse terms and conditions, or otherwise they'd be sacked. A quarter of those who responded to the survey said that their terms, such as pay or hours, had in fact been downgraded since the first lockdown in March last year. Now, there are some prominent examples across several sectors where this is occurring, including British Airways, who have abandoned their plan, Evans Cycles, who propose to move to controversial 0 hours contracts, and also British Gas, who are currently engaged in a high-profile dispute with their workers over this. So I suppose it makes sense at the outset to provide a brief introduction to the law in this area. And the starting position, broadly speaking, is that changes to employment contracts cannot be made unilaterally. So this means that you should not seek to impose new terms and conditions without the consent of the relevant employees. If you do, that this could lead to a claim of unfair dismissal, assuming that the employee in question has the qualifying 2-year service period. And Sara, I think you were going to say something about the difference between fire and rehire and other changes to terms.
Absolutely, Emily, because I think it's important that people keep in mind the full gamut of changes they can make to employment contracts. Well, some changes, we should note, are likely to be uncontroversial. So if you're going to improve pay or benefits, that will probably be quite readily agreed. In some instances, you may be able to rely on so-called variation clauses in an employment contract. However, we've both noted this ought to be done with some caution because the courts do narrowly construe these clauses and they aren't intended to confer a right on employers to evade the general rule that variations ought to be mutually agreed. For those that do intend to use their variation clauses, they should seek legal advice addressing whether the clause is clear and whether it in fact covers the proposed changes they wish to make. You can sometimes impose changes and see if your employees are going to object to those changes. However, the courts won't often find that silence is sufficient to indicate there was implied agreement to the variation. So this is particularly the case if the change isn't going to take immediate effect for the employee. And finally, I think we ought to deal with the issue of express consent. So this is seen as the textbook way to approach changes to employment contracts. It is the most straightforward way to ensure that your terms and conditions will definitely take effect. However, we do know that during the pandemic, with periods of remote working, this can get logistically complicated, particularly if you have very large groups of employees who are likely to be impacted. But Emily, on that note, there is some ACAS guidance, isn't there?
Yes, there is, Sara. So ACAS has some specific guidance about changing employment contracts. And they caution that fire and rehire should be a last resort and should only be considered if the following 4 criteria are satisfied. So firstly, everything has to be done to try to reach an agreement. Secondly, the changes must be necessary. Thirdly, the employee engagement and morale has to be considered. And fourthly, the risk of legal action has to be accounted for. So employers who are considering fire and rehire are told to follow a fair dismissal process, give appropriate notice to the affected employees, and also offer the right of appeal. Now, if an employer decides that they have no option but to terminate the old contract and offer new terms and conditions, there could be an unfair dismissal claim nonetheless, even if the employee accepts the new job. Now, this might include the ability to claim for the difference in wages or benefits arising from the changes to the contract. The right to have an unlawful deduction of wages, the right not to have an unlawful deduction of wages is covered by Section 104 of the Employment Rights Act. And that provides that it is automatically unfair to dismiss an employee for asserting their statutory rights. So where an employee has been fired and rehired on less favourable terms, they could have a claim for automatic unfair dismissal, as well as the usual claims for unfair dismissal under Section 98 of the ERA. There could also be an argument that this has created a redundancy situation as well.
So finally, where there is a threat to fire and rehire in the course of an employer attempting to change an employee's terms and conditions, this could amount to an anticipatory breach of contract. Now, the reason that's important is it could entitle the employee to claim they have been constructively unfairly dismissed. So we're setting out some of these difficulties to ensure that employers, if they do follow this route, know that it can be fraught with difficulties, both if you're an employer and if you're an employee. So in those circumstances, Emily, is there anything that can be done to try and make sure there's fairness if there is in fact going to be a dismissal?
So typically, Sara, when you fire and rehire, the fairness of the dismissal will be on the grounds of some other substantial reason. Now, the prime consideration for an employment tribunal will be whether the employer acted reasonably in all the circumstances in dismissing the employee. And there are two cases that we thought might be relevant in these pandemic times. They are both EAT authorities. So the first authority is Garside and Laycock Limited and Booth. And in that case, the EAT suggested that a factor in determining the reasonableness of dismissal for a refusal to accept a pay cut could be whether or not members of the management were also subject to the cut. And Sara, I think you were going to talk about the second one.
Yes, that's right. So, Emily, we also thought the case of Catamaran Cruises and Williams might be helpful. So the EAT in that case said that any employment tribunal approaching this issue must examine whether there is a sound business reason for making the changes and whether the employer has acted arbitrarily. So this could include whether an employer was actually facing financial hardship, that's likely to be quite relevant now, or trying to avert insolvency, again, something that could be highly relevant to a lot of employers at the moment. So we need to recognise that hire and refire ought to be seen as a last resort for employers, and it shouldn't be assumed that it's a quick fix or that it's in fact easier than following a redundancy process. There has to still be a well thought out business case, and you have to follow proper procedures. So, Emily, our advice to both employers and employees in this situation is they ought to seek legal advice. And that it is particularly pertinent in a case such as this, when these tactics are being used. Though we do say to all of our clients, if you do have any questions, the employment team will be more than happy to help you. Thank you very much for joining us today.